Welcome to Finding Common Ground, Mediating the Complex Financial Case. I am Ryan Wedeking, co-chair of Beverly Hills Bar Association's Family Law Section. The Family Law Section is sponsored by White, Zuckerman, Warzowski, Luna Hunt LLP, Lawyers Mutual, SoberLink, and Our Family Wizard. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. SoberLink provides objective real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that Lawyers Mutual is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including family law. Learn more at lawyersmutual.com. Last but not least, Our Family Wizard is a co-parenting platform designed to help families communicate more effectively, reduce conflict, and create reliable court-admissible records. Features like tone meter, AI, shared calendars, expense tracking, and in-app audio and video calling help support compliance and better outcomes for families navigating custody matters. Now, for our speakers today, I am delighted to introduce Chris Melcher, Tony Storm, and the Honorable Joshua Walzer. Chris Melcher is a partner at Walzer Melcher and Yoda LLP, where he focuses on complex family law litigation, including property division, business valuation, premarital agreements, and the tax consequences of divorce. He is certified in basically anything that you can be certified in, including CFLS, certified specialist with the appellate board, and holds a board certification in family trial law from the National Board of Trial Advocacy. Tony Storm is founding partner at Storm Palyan LLP, where his practice centers on resolving complex family law matters through mediation, arbitration, and collaborative approaches. And I should add that Tony Storm is going to be founding partner at Storm Palyan LLP until June 1st of this year, after which time he will be joining Signature Resolution as a trained mediator and arbitrator. In those roles, Tony brings a settlement-focused mindset to even the most contentious custody disputes, helping families reach lasting resolutions outside of court. The Honorable Joshua D. Walzer, I think, needs no introduction, but I will introduce him anyway. Judge Walzer is a judge for the LA Superior Court. He succeeded the Cesar C. Sarmiento, who received, I think there's a typo in here. Anyway, Judge Walzer was appointed by Jerry Brown on November 17th, 2015. Judge Walzer received his BA and JD from Columbia University of Law. And as you all know, he is a great resource for families in LA County. So with that, I will let the speakers take it away. Let's get started.
Thank you, Ryan. I appreciate all the kind words. Chris and Judge Walzer, in my opinion, are some of the best we have here today. Chris knows how to litigate a case and settle a case. We've settled countless cases with Judge Walzer prior to trial. He's one of the best bench officers, I think, and I think we're very lucky to have them here for this panel. What we're going to do today is discuss how to settle a complex family law financial case. We've divided this program into 3 areas: how to prepare for the mediation. What techniques are we going to do at the mediation to have a successful mediation? And once we reach an agreement, how do we draft very clear and concise settlement documents? I think it's really, really important to have all these concepts down pat in order to have a successful mediation. Mediations can be difficult and emotional, but if you prepare properly and know what you're getting into when you're there, you're much more likely to have a successful mediation. Chris, you want to tell us at the beginning about the preparing for a mediation, how to prepare your client, how to prepare the case, the landscape of a successful mediation?
Sure. So as experienced counsel, if it were just left to us attorneys, we could probably settle most of our cases early on. Obviously, we need information. We need to understand where each side is coming from, but we've done this long enough. You know what your case is worth. You know what you can sell. You know what is a solid position versus a stretch. And, so I've always been interested in that. Like, why is it that the attorneys can see that, the parties can't? And obviously, the parties don't have our legal training. Even if they did have this understanding that we do about family law principles and procedure, they're too emotionally invested in it to really see this. And also, they just need to be brought into, this world here that we live in, and to get acclimated to it, and then understand, like, okay, this is happening. Are they ready to proceed? Are they really want to end their marriage or just conflict? Do they even know what a good deal is? Maybe there's options that they haven't even thought about before. So that's the world that initially I think we have to look at, is where are these two parties emotionally and financially? Are they ready to settle? And if there's barriers there, how do we overcome those? And so what I'm looking at is really three things that are necessary to get a settlement. We need to have good communication. We need to have respect for each other, and this ability to trust. And all those are broken in a marriage. For the most part, not every time, but many times, those are all broken. We have no trust, respect, or communication. And so what I view as my role is to try and build those things, building communication by saying, hey, I'm ready to listen to you with respect. I'm not going to diminish anything you have to say. I just want to know where you're coming from, where your client's coming from, and building trust through disclosure. I'm going to give you everything.
I think part of that, Chris, I'm going to try not to step on your speaking. If I do, just stop me ahead of time. And I apologize for how I sound. I have a cough and lost my voice a little bit. But I think part of that mediation prep is really preparing your client. Know what you want and have a roadmap of how to get there. Give them the reality checks that they need.
And if I might,
go ahead.
Tony, what is the exit strategy? What I often find is that people have not had the basic discussions about, okay, what will you be left with at the end of the day? How much money will you have? Where will you be living? How much will that cost? Do you have enough money to pay your bills? And so, especially in high dollar cases, people sort of get lost in those details. But when you ask us, for example, to do a spousal support award, it's the most nuanced, detailed, well, what are you going to spend on this? What are you going to spend on that? And I find that people are often coming to these mediations without having thought about, okay, have I talked to a financial professional? How much will I have? What's my life going to cost me? And what's a realistic number?
Well, I think in part of that, it's not just preparing your client and getting these reality checks and knowing where the settlement, what do they want to settle on? Where do they want to land the plane? It's preparing your case really well. And that's really part of what Chris was getting into. We start every case with a case map. I remember when I worked with Chris and Peter at their firm, Walzer Melcher, Peter would always say, you should be able to draft the judgment at the beginning of the case. And it's actually an interesting exercise to do that because it really helps flesh out what you really need and lay the breadcrumbs of how you want to get there. So I like to prepare a case map of the issues. I like to prepare a timeline of what happened. Part of your brief is going to be, what are the disagreements? Where do the parties agree? Is there an agreement on methodologies? Have the experts met and conferred? Is there any disagreement about inputs? This a laundry list of what you want to do to prepare your case. And really, I mean, for me, I really like to have a checklist going in, identifying what's at stake. What are the assets in dispute? Not just categories. Go ahead, Judge Wazer.
Well, and also, what happens if you don't settle? I've been talking to my colleagues for a number of years now about a family law judge's obligation is to divide the community property. It is not to make soft landings. And so every case that I get, I always say to everyone, you need a soft landing. You want a soft landing. You want that house, or you want the boat, or you want the children to go to private school. That's a soft landing. Uh, and my colleagues are public servants. They're not in the business of making people's lives. I mean, we try our best to make people's lives nice. We don't try to be intentionally difficult, but it is not our job to say, okay, you get this on the balance sheet and I get this on the balance sheet. If there's disagreement, we just say sell it. And I think judges are getting very savvy to that. And it then forces the issue because if you don't settle, what is actually going to happen? And are you prepared to give up that low interest rate mortgage? Or are you prepared to find a new house? Are you prepared to have the business sold? So you almost have to settle by definition. And if you haven't figured out what happens if you don't settle, it's a problem.
Well, I think those
Yeah.
soft landings happen in settlement. That's the opportunity for the parties to really navigate their future without a judge saying, giving them a short amount of time and saying, this is what's going to happen. We're just going to sell the house. We're just going to sell the business, or whatever is going to happen with the business. Somebody's going to get it. This is the value. I think preparation is key to settling anything or trying a case. For me, I'm very visual, and it helps me when I'm in settlement to have a side-by-side analysis of what's each party's position. Are fees an issue? Is there a dispute over income for support? Your brief is really an important part of that. And what you do prior to the mediation. I'm going to skip ahead a little bit briefly and talk about when I mediate. Most of us in these mediations, the offers don't get passed along till after lunch. And I think that's a problem. I think the first half of these mediations are spent talking, establishing rapport, which is important. But I'd like to see some speaking to the attorneys and the parties before the day of the mediation so they come in prepared and know where they want to land the plane, know where they can have that soft landing. So you're not spending the first 3 hours trying to get some idea of where you want to go on the table.
Yeah. So just trying to keep in sequence here, right? Because we all know everyone wants to settle a case. We know that's better than going to any other alternative. But we're really looking at the beginning of the case. And yeah, the client needs to understand all these range of options. Very, very difficult, though, to get all that information, do the assessment, but it's necessary to produce a result at mediation, or if we're not going to settle, go to trial. So I'm looking at early stage in the information gathering part of it and doing our disclosures, because we absolutely need to do our disclosures, whether we're going to litigate or settle. That's 2105 A requires the parties to have exchanged their final declaration of disclosure before any settlement on property or permanent spouse support. There's no waiver of that. I really wish the Judicial Council would get rid of that waiver of FDD form, because when you look at 2105 and the form itself, it's just verifying that you've given all the information that an FDD would require. So we're not waiving anything, we're doing it. And that's really starting the case, preparing it for settlement or trial. And as we're going through a very thorough disclosure process, then we get to learn, what are the assets and debts? How are they titled? What are the valuation of these things? What are issues around? Maybe we do have a low interest rate mortgage and we really want to keep that mortgage, or maybe we have a business interest that's non-sellable, but it's worth a ton of money. So we're going to learn all that stuff and see where the rubs are. And to me, all that groundwork is what's preparing us. So my first pitch is, do those FDDs very seriously. And when I'm talking to people in the office and they're saying, oh, I'm going to mediation or whatever, it's like, okay, do you have an FDD from both sides? And if the answer is no, then you're not ready. You're not going to settle. You're not capable of settlement. And because if there's no FDD, basically the other side has an opt out and saying, sure, I signed the MSA, but there's no disclosure. So I could set that aside because under 2105. So we have to do that work. And then we're able to then again see the range of options that are available for division and for support, because that's obviously related to the property division. So all this complex work needs to be done up front to get ready into the mediation, working with a forensic accountant, working with a financial advisor. And and this is helpful here. We have the resources of a lot of financial advisors who will help a client do a budget going forward or help a client understand what their income could be. So I like to bring those folks involved too.
Well, Chris, you and I both saw the disclosure issue come about on the appeal for the LAPI case, where that question was there an adequate disclosure in mediation, and was it admissible or confidential?
And then there's always marriage of Worcester to add to the mix. I would say this about the assets, and I see this just as a settlement judge. I don't have any magic mojo. I just simply realize, okay, this is what you haven't done. Well, this is what we're going to do, and then we'll get the case settled. So a lot of times I do see people showing up without the forensics having meaningfully met and conferred and exchanged information. And I'm always flabbergasted, given what the family code says about the voluntary exchange of information to determine the community, how infrequently that happens. And I'm also sort of surprised at how many people come to a mediation and they haven't called the bank to say, is this loan assumable? Many banks are allowing people to assume out of a divorce, but some aren't. And that's stuff that you have to know ahead of time, not at the mediation. And so, and also, how about calling a title company to get a preliminary title report on real estate, just to see what's out there, to know what you're dealing with? That old saw, knowledge is power. Well, you have to have it in order to settle, because otherwise you can't. And otherwise you also have risks for malpractice if you haven't done your due diligence.
And that FDD is really your roadmap. It's an outline of what assets there are and what exists. It should show whether you contend something is separate or whether it's community property. And it's very, very helpful. I mean, you have to know that. You have to know the contentions in order to resolve those issues. Your brief really should outline what's happened in the case. What are the issues in controversy? What are the parties' positions, and what you expect to get the plane landed, as I keep saying. Yeah. Go ahead, Chris.
So one thing is that we're seeing is there are roadblocks. Like you'll have a premarital agreement that's contested, or you'll have an estate that somebody says is all separate. And those are pivotal issues. And how do we settle in the face of that undecided pivotal issue? Well, what we've been doing is kind of gaming this thing and saying, okay, well, if this party's right, what is the outcome here on property and support? If the other party's right, obviously, what is that outcome? And when we're dealing with a prenup, sometimes even if there is no prenup, it's invalid, the estate is still separate anyway under law because it's mostly premarital or maybe the outgrowth of separate property during marriage. So what we're doing in the disputed prenup cases is we'll say, okay, let's see a basic balance sheet. How does this come out with property and support if the prenup holds? How does it come out if there's no prenup? And sometimes there's a vast difference. Other times the difference is not that great. We've also done it with the separate property claims. We have somebody who maybe is going to prevail on the SP claims, but then get hammered with support. And to me, I'd always have property rather than support because support is terminable and property is vested. But there is a left pocket, right pocket concept happening there. And so the more separate property somebody wins at trial, the more support they're going to be able to pay and the more need that other party's going to have because there's no estate for them. So those are the things that really unlock what seem to be immovable objects, is just saying, look, we win or lose on these issues, we can kind of game how that's going to happen and come out. And that's been extraordinarily helpful when we're able to do that. I would just say some are afraid to do those calculations when they're saying this prenup is valid. I won't even spend a moment doing a calculation otherwise. But we can wrap that up into confidentiality and saying, look, we know you're giving us that schedule on the basis that you believe the prenup's valid. And you're really just trying to show that even if our position is right, that there's no prenup, that there's still no money here. So this is a very effective tool to break through are seemingly insoluble problems.
That loops exactly back to Judge Wazer's comment about having an exit plan and strategizing your case and knowing what you want, doing the side-by-side analysis, because if you don't have that analysis, you're flying blind.
And also, who's going to have the hard conversation? And what's the lawyer's role? What's the mediator's role? Unfortunately, every once in a while, I have people cry because I have to be the bearer of bad news. And it's an expensive world out there. And there are very few people who have vast wealth that doesn't get hit by a divorce. And so the question then is when to have that difficult conversation with your client and who's having it. And frequently that happens at the mediation, and frequently it's the mediator's job to sort of say, well, wait a second, this isn't going to be that pretty of a situation. It's impossible to have two households live on the same salaries.
That's my experience as well. A mediator is often the one who is the first one to broach those conversations. I think it's really important to get some of these issues out in the pre-mediation conference, which is why I like to have those conferences. I like to have a conference with the attorneys separately. I like to talk to them about what's driving the issues, what's really in dispute, fueling the fire, try to figure out the floor and the ceiling on each party's side and bridge those gaps. But I think also people need to be heard, and they also need somebody to give them a reality check. And I think the pre-mediation conference with a party is very effective. Often it happens at the mediation, the day of, the judge goes or the mediator goes from one room to the other, and they spend an hour in each room. But it would be nice if that could happen before that day, and the parties can spend some time thinking about what the mediator said, considering some options to settling. Before that happens, there's also a lot of prep that the mediator ought to be doing. They ought to have seen the orders in the file. How has the judge ruled? Maybe you think you've got a great case, and every time you get in front of that judge, you lose. I know when I'm most confident going into court, that's when things go south. There's always something I haven't thought of. And sometimes when I'm going, oh, this case is not a great one, and I come out winning, and it's remarkable. There's always something that happens or tends to happen, but I do think preparation is key. I know Chris, when I worked with him, prepare. Know what your issues are. That's part of what he's getting at. Know what all the options are for settlement. When you go in with knowledge, like Judge Wazer said, knowledge is power, and it will help you get across the finish line and know where you can meet.
Antonia, I'm a big fan of the pre-mediation call, and I will frequently email on sophisticated counsel cases with sophisticated financial issues and say, we need to get on the phone ahead of our mediation. I mean, it's just plain common sense. If you think about what we're trying to do, we're settling the estate. That's quite a thing sometimes, especially with complicated financial issues. And the idea that you're going to be able to do that in an afternoon or a day without sort of sussing out ahead of time what the ramifications are and why is it that we're in this place, 90% of the cases settle on their own. So if you're actually getting to a mediation, there is some dysfunction there, either in the nature of the relationship between the parties or the lawyers or whatever it is, there's a disconnect. And figuring out what that disconnect is critical for then being able to say, okay, this is what's going on. And on the point you made, Tony, I can't tell you how many times cases settle simply because people feel heard. And I spend 15 minutes or 20 minutes or whatever it is with them saying, yeah, I understand from your perspective why this has been an unpleasant situation, and I see what's gone on. Now that we've seen that, let's move forward.
I'll tell you what's really interesting. Sometimes when you map the issues, for example, like Chris said, the premarital agreement is enforceable or it's not enforceable. You find the parties really aren't that far apart. And there's something more fueling the fire beyond the finances, the pride, the need to be right. And it's important for the mediator to break through that and get the case settled. Otherwise, they're not going to be happier after a trial.
So one thing that has been very effective for us, but does take, again, it's the prep, is to do that proposed judgment in advance of the mediation. And this is so hard for us to do because we just don't have the time or resources, every time. But if you can,
Chris, one could argue you're going to need that judgment one way or another. Settlement,
right.
mediation, whatever it is, someone's going to be drafting that judgment, and it does help you. I think it's an outstanding idea. It helps you flesh it out.
Thank you. Yeah.
Really, sorry. They're always very, very impressed when you come in with a judgment ready to sign.
Or how about this? And forgive me for interrupting one more time. Please bring a computer and please bring a deal memo form or STIPs. I mean, we have STIPs, but come ready to go.
Yeah. So what helps, and and I've learned all these lessons the hard way, okay? But if you write the judgment in advance, and I'm not talking an MSA deal memo, talking a stipulation for judgment, ready to sign. So now like, okay, what assets are being awarded to each party. Then you might say, wow, okay, that asset's actually held by a business or entity. Do you have the ability to transfer that? That's going to queue up a lot of stuff. Oh, this is a joint bank account. How are we going to get rid of that bank account? You start opening up a lot of issues and you thought them through. In a lot of my cases, there's just like my client's getting pretty much everything and there's a huge equalization payment. And that's just a configuration, a lot of my cases. So I'm saying, okay, I'm listing everything my client gets. I'm listing the maybe a few things that the other side gets. And then I have an equalization payment and I leave it blank. And I'm saying, hey, all we're talking about in this mediation, and from my view is we got the language. All we need to do is fill in that blank. How many millions of dollars do we need to get this done? So if you can isolate it like that, then it's like, okay, I get it. And then we avoid the problem that happens at, usually towards 5 o'clock at a mediation when we think we have an agreement and we're starting to then write it up and somebody says, oh, no, you're not getting this. That's supposed to go to me. And that's like where I lose, all semblance of my dignity here and just go crazy. And because of that miscommunication. And so going in saying, hey, we're working off this one document is great. What we've seen though, and I remember going downtown and somebody be scratching out by hand some agreement on the STIP form, and there would be like crossouts and there'd be an arrow that would point you to the back. And then of course we're going to have all kinds of litigation over that thing later on. What does it mean? So it's just a huge fail after all that prep.
Another really useful tool in case not all the assets are going to one party is having a community property balance sheet
that's critical.
Automatically do the math, where you put one investment account in husband's column or wife's column and the equalization figures out at the end, because it makes, even if there's a change to the judgment, it makes it pretty simple. You can also attach that, not necessarily as if there's a deal memo, not a judgment, you can attach that to the deal memo and it outlines who gets what the payment is, what the values are. It's part of what you need to do anyways when preparing your FDD. And frankly, oftentimes I prepare my schedule of assets and debts on a spreadsheet that I can easily move the values on into different people's column so we know who's getting it and who's not and what the math looks like. Because at the end of the day, everybody needs one number, and that number needs to be palatable. And it's easy to say, $100,000 goes to this person, $1 million goes to this person, but they may not realize what the equalization payment is. And sometimes if they're not prepared for that, they'll go, how am I going to pay that?
Yeah, another thing we're seeing is these equitable apportionment claims, credits and reimbursements. And, the thing is again, it makes it difficult to settle when somebody's saying there's this gigantic claim out there that they haven't necessarily quantified and it's resolved. There's a bunch of disputed issues, factual issues around it. So basically, is the juice worth the squeeze is the concept there. And so we can kind of game some of those things and saying, okay, well, if it's a Van Camp, for example, how much compensation would this person really need to make to provide anything to the community after the beam credit? So, you're going to get compensation to the marital estate for the efforts of the spouse and their separate business during marriage after taxes. So you deduct that. And then under beam, they get a credit for the separate property that was used to pay the community living expenses. And only after then, there's a community reimbursement left over, and you divide that by 2. So we can kind of game these things and just saying, look, even if there is the equitable apportionment, the comp would have to be $3 million a year or something like that to make for $1. Same with reimbursements and credits. Like, if we went through that whole exercise, is it going to be a wash? And how much money are we going to spend on it to get to that result? So these are some ways that we can kind of break through the jams. But we also have to practice with our risk in mind. And I hate saying that or thinking like that, but it's very true. That obviously we're a zealous advocate for our client and we think there's a great deal. We want to make that deal, but some of us do get sued from time to time. And so I think we just also have to cover ourselves. And does that mean, we got to take every depo and send every subpoena and go to trial on every issue? No, it does not mean that. But when we're settling early stage, when for most of my clients, the best deal somebody's ever going to see is at the beginning of the case, not the end. And that's when, the people are sometimes more generous. Sometimes they're totally out to lunch, but sometimes an early deal is your best deal. But that means we haven't even served a form interrogatory. And now, like, I'm going to settle that, or you're going to settle that with no discovery conducted. What is our exposure? So we want to document that with the client. And it's so that they have their informed consent. So they're actually getting real value out of your letter, so that they have informed consent. They know that they have the right to go to a hearing, do discovery, get an analysis, hire experts, and get a judge to decide everything. But they're giving up that right because they think this is a better deal. So it gives them informed consent, protects us. And I encourage you to think about those things because, again, we don't want to have these problems come back to us later.
Right. And part of informed consent is ensuring that your client knows what they're leaving on the table and is comfortable giving that up. And it's important, in my experience, to have that in the writing. Too many times, sometimes we have I remember I had one mediation, went till 11:30 at night. We reviewed the deal memo, must have been 11 times. Every sentence, every period, everything done. My client was an attorney. She understood every part of it. But then the next day they go, I don't remember that. That's what we agreed to. And it's important to ensure your clients understand, even though full well they do. Sometimes they Monday morning quarterback the next day and they go, I really want my day in court. Which is also why it's very important to make sure that you have a signed writing at the end of that, because
with a voir dire, hopefully, of the parties. Even though I don't have a court reporter, I will often swear parties in and make findings. Because if I've spent the day with you and I've been able to interact with you and be able to see, all right, you look pretty competent to me. And, I ask people all sorts of, the duress and coercion and the this and the that. Uh, it's worth taking the 5 minutes if you have a retired judge or a judge to ask them to do that. And then I will make findings in my minute order that I've voir dired the parties. And based on, I spent all day with them. It was my understanding of that this was a knowing and an intentional deal. And you have to document that as many ways as you can to protect yourself and to protect the settlement.
Yeah.
I think the theme in preparing your case for settlement and for mediation is preparation. I can't stress enough how you have to know your case inside and out. For me, preparing for complex mediation is akin to preparing for trial. You need to know every issue. You need to know what the options are. You need to have conferred with your experts and know what the different avenues are and have them available. Because guess what? We hire experts because we're not experts. I can't, I would love to say I know everything that our experts do, but that's why I've got them. If I knew everything, I wouldn't be hiring them. So there's tons of stuff they know better than attorneys, and we want to utilize their knowledge too and make sure that they're available for those mediations.
So one thing to remember is there's a mediation disclosure requirement under Evidence Code 1129, and that's under mediation confidentiality sections of the Evidence Code. And post Lappy and some other litigation that we've been involved in, there's been, this creation of 1129 would basically, we as an attorney have to warn our client that everything that's said in that mediation is confidential, and they may not be able to use that information for post-settlement litigation. And so it says the attorney shall obtain the client's acknowledgement on that form, and 1129 provides a sample form. So I'm putting that as part of my legal services agreement. I know that's like way early, but the reason why I do that, that's part of my LSA package for the initial signing up of a client, because I know I'm going to get them to sign the legal services agreement before I'm doing anything. So just throw in the mediation thing, and I got it there.
If I might, Chris, one way I get cases to settle is that I say to everyone, all right, well, we all know that what we're discussing is confidential, but we also know that counsel is going to walk out of here and send you a letter saying, I'm making you the following offer. It might be the offer that Judge Walzer recommended. And by the way, here it is in writing. And if you do not do better at trial, I'm going to make the argument that you should be paying my fees, or that you shouldn't be entitled to any fee contribution because I made this reasonable offer, usually the one that I suggested to the parties.
Yeah.
And the lawyers sometimes look at me like, oh, yeah, I hadn't thought about that. Like, I should
Yeah.
be sending this letter. But it's one thing, you've got to maximize your leverage. And one of the great ways to maximize your leverage is to say, are you going to do better at trial on this? And are you going to be paying my fees? Am I going to be paying your fees? And that is the other, I think, critical thing that people do not necessarily focus on, which is, okay, what happens if we don't settle? Where's the money coming from to litigate? Are you going to get paid to litigate? If you're not getting paid to litigate, you got to be thinking about that. And I will frequently say to people, could you please open your wallet? Do you have $100,000 in your bank book? If you don't have $100,000 in your bank book, why are you talking to me about these issues? Because you can't afford to litigate it. So the preparation for sort of understanding what happens if we don't settle and the financial ramifications of that, I think, are very significant.
Those 1129 disclosures are also contained in a judicial counsel form that I urge everybody to look at. Whenever there's a form, I like to use it. I include them like Chris does in the legal services agreement, but sometimes 2 years go by between when they signed your legal service agreement and the mediation. So resend that out, remind them so they don't say, well, that was 2 years ago, and make sure they know to ensure that your basis is covered, that they know what they're getting into with mediation.
Yeah.
So go ahead, Chris.
Yeah. So one thing is, talking about the drafting, because we already talked about drafting a judgment in advance, but obviously a lot of times that happens after the fact and of a settlement. And one of the things we wanted to bring up is like the Smith-Ostler, language, the dreaded Smith-Ostler language. And I look, I love the concept of Smith-Ostler. You have variable income. You want to make sure no one's overpaying or underpaying support. It's a beautiful mechanism for that purpose. But wow, does this generate a lot of post-settlement litigation? One, because there's no trust, so everyone's thinking they're not getting what they should get. But the language itself leads to a lot of problems, and you're going to see these things drafted very quickly, like 20% of all income. It's like, what does that mean? And so I'd really encourage everyone to tighten up that. For example, if it's a child support case, what I would say is it's X percentage of all income as defined in section 4058 of the Family Code over whatever $500,000 a month gross annual income as reported on their tax return or something. Make it as specific as possible,
And then
because
also, Chris, if I might, make it contextual, because if you've got a client who is a chief executive of a business that's privately owned but may get bought out, you want to have an Osler-Smith problem, just wait for that to happen.
Yeah.
So figure out what business this person is in, and then figure out what are those twists and turns about, is that income or is that a capital event? And so anticipate what it is. And, compensation evolves over time. That's why we have comp experts. But there's so many different now permutations about how we get people compensated, and the definition of what is income and what isn't income is mission critical and should be contextual if you can manage. And my other last piece is, please do the math. I love when people give for example, if X, Y, and Z happens, this is what the calculation is going to be. Show the math, do the math so that no one can dispute it.
Yeah, and I've had some horrific litigation over this, and for example, the sale of the business. So there's some Smith-Ostler, it's poorly constructed language, and somebody now has some exit event of umpteen millions of dollars, and they're successfully arguing that not a penny of that is going into the Smith-Ostler calculation. Or another case that I had, trust fund distributions. So the guy got millions of dollars of trust fund distributions. The court said that's not income. And so we want to be, like I say, if it's child support, 4058 of the Family Code is extraordinarily broad. So that's one way of going. But you may want to say, like Judge Walzer is saying, hey, if this person's a business owner, trust fund baby or whatever, it's saying that specifically this includes cap gains from a business sale, or this includes non-taxable gifts or distributions from a trust. If that's the expectation, just please write that out, because it's like I say, it leads to inexorably some very nasty litigation with some really bad outcomes for somebody.
So specificity is really key. I mean, they say oftentimes garbage in, garbage out. So to the extent you can resolve income disputes, not incomes, excuse me, input, what are you putting in the ex-spouse? Do you
And
agree?
also, careful about those bonus tables, please. And the language on the bonus tables, the devil is in the details, and be very careful about that.
Yeah, I mean, I think a lot of this can be resolved when you have people confer prior to the mediation. Are you going to use Nelson or Hug? Are you going to, what's the cap rate? Figure out, can you trace this? Can you not trace this? Are you bluffing? What's the strategy?
I'm so glad you said that, by the way, Tony. When it comes to tracing, I think we all understand that in family court, if you don't have evidence, you can't prove it.
Right.
But in settlement, I always like to say to people, like, for example, when you purchased your house, I don't want to admit this, but 34 years after the purchase of my first house, I can still tell you the exact amount of Price Club shares, which is now known as Costco, I had to sell to be able to acquire my first house. I understood that within an inch of its life, because it was the most serious financial transaction I had done in my life. So when I talk to people about settlement, I say to them, okay, there's always the issue about what is it you can prove in court, but what do you know to be true? And, when you purchase a house or you purchase a business, those are major things that people usually discuss. And if we're talking fairness, I always like to say to people, well, what actually happened? And by the way, you're not going to have documents from the bank, or you're not going to have documents because they aren't kept that long, but call the mortgage broker, call the real estate broker. A real estate broker knows exactly where the money is coming from to purchase the house because you're talking to them. And so often I find that the easier sources of information that would make sense, people haven't thought about. And I always just say to everyone, take 5 and call the broker. The broker will remember who was buying the property and where the money was coming from.
Yeah.
And some of
So,
these things, go ahead.
well, the one thing I wanted to get Judge Wazer's input on is, mediator recommendation, and
Oh,
here's
that's
where
a
I'm.
hot topic.
Yeah, yeah. So like when, sometimes going into mediation, some people will insist on, hey, I want to know what your position is before I go to mediate with you. I really don't like to do that. It just kind of brackets everything and makes it very positional. So a lot of times I just want to encourage the mediator to recommend something. Maybe I'm saying, hey, if it was within this range, my client is cool with it, then it's because anything that I recommend or offer a lot of times is just rejected because the other side just doesn't trust it. But Judge Wazer, do you do that, or do you suggest holding it to the end or not doing it at all? Or
I do it all the time uh, because it's the only way to break a logjam. Now, there is that issue about the American Bar Association. I think it's opinion 518. I think that arguably applies only to lawyers acting as mediators, and I certainly don't take it as restricting my ability. A lot of times people just need the help of having someone who isn't the other side's lawyer, who, your party hates. And unfortunately, that's the practical realities of it. Having someone say, well, this is what I think makes sense under the circumstances. Why not let me make a mediator's proposal? I do it all the time, and I think it's very helpful.
Sometimes if you could do that too with the low-hanging fruit, the smaller issues in the case, and you establish some agreements, it
And
really
document them immediately and have them signed. I love a nice interim stip in a settlement about, all right, we're selling the property. How are we selling the property? What are the rules of engagement? Who are we following? What happens if we don't agree? Uh, Document it, get it done quickly, and make sure it happens.
always be closing, I say. So
Yeah.
whatever you've got, try to close it as you go. It paves the way for future agreements when you have something settled. Write it down sideways. That way you can always come back, and you can always utilize that concession. Well, this party really conceded on this issue, and they gave on it, and maybe they can get something for a simple concession that may not be meaningful in the long run to them.
and I've seen the approach, to me, I'm more like, hey, I want to focus on the big stuff, and then all the little stuff will hopefully, fall in line. But sometimes people will hold on to the little things. But I have seen the other approach from mediators saying, let's see what we can agree on first. And, we spend an hour and now we agreed on the date of marriage. Awesome. Clap. We got that written on the board. Check. So it's nice to like model some behavior and see, hey, we could agree on things, but I do like to focus on those big things. Um, and yeah, on the mediator recommendation thing, I'm trying to suggest these, and into saying, hey, maybe here's my official position, but if it were over here, mediator, I think we could get this done. And it kind of gives some optionality, at least, to the mediator to do that. Um, I don't know. The other thing is, I'm going into one now. It's a 2-day mediation. I hate it, but I think it's necessary. But I'm always worried when I schedule these 2-day mediations. Day one is just a waste. I don't know. I mean, I know we're going to do the groundwork, but if you have 2 days, no one settles on day one of two. I just feel.
Well, that part of the problem I see is the real offers don't even come to the afternoon of the first day. And if there's a second day, they never,
Yeah.
they always come the second day. And I don't like that. I think media proposals are great. If that's not something you can do and you want the parties to come up with their own proposals, help them do it. Ask pointed questions to them to help narrow. Sometimes people come into mediation, you get these horrible briefs where they just lay out the procedural history and nothing else. And they don't know what they want. So if you can help them find what they want, when they're stuck, when they're jammed up on an emotional issue, bring them to a practical solution. by asking these
And
questions.
also have the difficult discussions that you have to have. I mean, we call it permanent spousal support. That is a misnomer, given the practice in this district with respect to filing motions to modify. And, life happens. And I think you have to have the conversations with people about, all right, what does permanent support mean? And is it really permanent? Uh, when's the last time you settled a case with non-modifiable support? It doesn't happen that often anymore. And so the conversations about, all right, what are you getting now and what are you buying into in the future? Most of the time, everyone just wants to be done. And they want to find a way that they don't have to come back to court and avoid having to see a judge or talk to a lawyer. And so figuring out what those roadblocks are ahead of time and talking to your client about it, I think are mission critical.
So the other thing I've seen complaints about is we have the lawyers go into the room with the settlement officer, leaving the parties behind. And then we're in there for an hour or something like that, and we come out and we're like, with some recommendations. And I've had clients, I could just read their face and thinking like, okay, you're sitting here talking about my case. I'm not involved and I don't know what's happening. Feel like, they're paying for everything. It's their life, but they're not invited to the discussion. So I really don't like doing that. I mean, sometimes there is some need to have a conversation just with counsel and the mediator to kind of break through some issues or at least set an agenda maybe. But I try and really keep those to a minimum. And so we're each going to have our separate rooms, but I really want the client participating, observing in all this so they don't feel like I orchestrated their life for them and then they just had to go along with it and now they're upset.
Well, I think sometimes in these mediations also you do reach an impasse and people are stuck. And I'm curious to hear from Judge Walzer on how he diagnoses that impasse and breaks that into a settlement, which I know you do so well.
Well, look, all right, what are your options today? I've never met anyone who didn't like their house and was excited about losing their house or the real estate that they own. Never, ever had anyone say, yeah, I don't care about my house. Everyone cares about their house. It's where you raised your children. You had your life. Uh, so the way to break through the log jams is to say, all right, what do you got in the bank? Can you afford this? If you can't afford it, what's the next best option? And are you being realistic about X, Y, and Z? Is your judge who makes $240,000 a year and works every day really going to be sympathetic to the claim of, oh, well, I can't do this or I can't do that? Well, we have to. So you know what the outcomes might be, and then talk to people about, look, what I always say to people is, I'm not a magician, but if I can figure this out, at trial, your judge will be able to figure it out. And how will that play for you at trial? So if you're being unreasonable in a settlement, your judge will be able to figure that out. And in an area of the law where the bench officer has not unfettered discretion, but significant discretion about what the equalization of the estate looks like, things come out in court. And people's behaviors come out in court, and you have to be mindful of that because if I think you're being unreasonable in a settlement, your trial judge is going to figure that out.
I
And
think you
sometimes I
really,
like to say, if they'll know if I can't get it settled, someone's not being reasonable. And then you want fees, and you want this, and you want that, and reasonableness is the hallmark of everything in family law.
sometimes there's a clear cause of the impasse, sometimes it's pride. When there's a clear cause, when you can see if is it math, is it methodology, or is it just emotion? When you can figure out what is causing people to dig in their heels, sometimes you can get past that and really address it and move to settlement. Now,
Another technique is, using the mediator is also a privately compensated temporary judge, or doing it in the public system with a waiver. And so your settlement officer is your trial judge if the judge will agree to that and the parties do. But it's scary, unconventional. But to my view is like, look, I want to get the case done. We know most of these cases settle. We know mediation works. but there needs to be an impetus for people to settle. And so if we're going into the mediation, we've done all this prep, and now they know, hey, if they don't act reasonably during this mediation, this mediator is going to turn into a decision maker. That keeps them on their best behavior. And also, if that decision maker is signaling, or potential future decision maker is signaling, this is kind of how I feel about this issue. I'm not giving a recommendation. I'm not like deciding it. These are kind of my feelings here. They're telegraphing, hey, this is how it's going to turn out. Why even fight this thing? So it works. But again, we got to get a lot of informed, we have to have informed consent from the client for that. And they have to have a judicial officer willing to go along with it. But again, it sure does keep people on their best behavior.
Given that we only have 4 minutes left, I want to highlight some really important things. When you can't draft a judgment before, it's great if you can do that. Start writing early. Start memorializing that agreement. Whenever I'm in a mediation, I always bring somebody, an associate, while I'm talking and doing things. They're taking notes. They're drafting from the very beginning. What's the settlement? What does it look like? So when we have an agreement, we're not starting our drafts late in the afternoon when everybody's tired, or in the evening. Sometimes we can't settle every issue. Chris talked about a second day mediation. Sometimes you settle what you can. Judge Walzer brought up have a settlement earlier, and then what you can't settle, you can always reserve on or come back to mediation. At least if you settle some of your case, in my opinion, you're going to narrow the issues for trial.
And Tony, if I might, all right, if we can't settle today, please tell me what it is that we need to do so that we can settle tomorrow or the day after or the day after that. So that's fine. If we can't settle it, fine, but I'm not letting you go, because you're going to tell me what it is that needs to be done, when it is going to be done, how it is going to be done in compliance with Family Code cooperative spirit and less expensive way of proceeding. And then we'll get back together and we'll get it done.
Define your terms. You want to avoid ambiguities. Make sure you include deadlines, not just that there's going to be an equalization payment. When is that paid?
Yes.
What happens if there's a dispute? Are you going back to mediation? Do you have an arbitration? What's the game plan?
And do you have a fee shifting clause for the party that loses?
What are the duties? If there's sometimes we have assets that are held in constructive trust. Make sure the people know in their duties that they have to act as a fiduciary are in the agreement.
Yeah, obviously a lot of prep goes into it. And part of that is also setting expectations. So again, if we have the funding and time, resources here, we'll set up some milestones and saying, okay, we're going to agree to a mediation. This is our mediator. Here's when we're going to get our disclosures exchanged. I might go first if I represent the in-spouse, then the out-spouse is going to go second with their FDD. When are we going to exchange offers, and who's going to go first, and when are we going to exchange those offers? So it is kind of like, project manage the thing. So we have expectations around it.
And if I might, and perhaps as a closing, if it's complex, why is it complex? And are you prepared to be able to explain it to the judge about what it is that's complex about it and why the judge should be buying your position or understanding your position? Be prepared to explain the complexity and have the math ready to go and anticipate the answers that you need to explain the complexity. Because there is very little that is actually complex once you know what it is, but you have to know what it is.
That's it. I mean, family law math is divide by 2. These are generally not complex issues. I think it's the people that are complex. And that's why when I started with my initial comments about respect and communication and trust, it's developing, these people here so that they are able to settle. And then a lot of times these do kind of fall in line. The issues, the division of property and support just kind of then becomes apparent.
The law is pretty clear. I think a lot of settlement is people skills and being able to draft an agreement that's going to withstand future scrutiny. And if you can do that, and if you can manage your expectations, you're on the road to getting this thing resolved, and people can go on with their lives happily. Nobody ever says that they're unhappy. The when they're finished their divorce. It's usually this huge relief that comes off their shoulders when it's finally done and both parties can move on with their lives.
All right, everyone. Thank you.